Hello and welcome. I'm Dr. J.C. Bowman. I'm the Executive Director of Professional Educators of Tennessee. Joining me on this webinar entitled Ethics Training for Educators today is Christy Ballard and Mike Shepard. Mike is the Associate Director of Professional Educators of Tennessee. He usually conducts these trainings for our members. However, there have been a few changes to the state law, and we want to make this training available to others. So we wanted to hear from the state expert on the issue, Christy Ballard. Christy is the long-term General Counsel of the Department of Education. She's originally from Tennessee, so she is one of us. Probably nobody in the state knows education law better than Christy Ballard, and I'm very glad she's here with us today to share her knowledge. The mission of the General Counsel is to provide legal services to the Tennessee Department of Education on day-to-day operations, as well as guidance and legal training to assist the Department of Education and local education agencies. The Office of General Counsel advises the Commissioner of Education and the Tennessee Department of Personnel, as well as the Superintendent of the 4 state special school districts on all legal issues. While LEAs must consult their local school board attorney for specific legal advice, the Office of General Counsel regularly assists in the implementation and enforcement of Tennessee's education laws and regulations, providing legal technical assistance to local school board attorneys, other state agency staff, legislators, LEAs, teachers, and the general public by providing the Tennessee Department of Education position on school-related laws and regulations. Upon request, the Office of General Counsel will design and provide specific training to meet an agency's needs. Let me welcome my friend and colleague, Christy Ballard. Christy, it's all yours.
Hello. That was a very kind introduction, and I appreciate it, JC. I'm happy to be here today to talk to everyone about some revisions on the law that were made during the past legislative session on teacher employment, teacher ethics, and teacher misconduct. There were several bills passed, and they traveled along through the General Assembly's process together. I don't think that the reason these laws were passed was because there have necessarily been more problems in the past with teachers doing bad things. But I do think that in the world we live in today, with the news media and social media especially, when something happens in California, we hear about it immediately in Tennessee and vice versa. I do think that because we are more knowledgeable about issues with teacher misconduct, we are better able to address them quickly to keep students safe. I think that the laws that were passed during this past legislative session are ones that teachers should not fear. They should be knowledgeable about them. I do think that having these conversations are important, and it actually helps the profession, and I'm glad to talk about them today. So let's start first with a new law that passed regarding teacher background check requirements. Public Chapter 1006 amended the longstanding law that requires every school district upon hiring a teacher or any other position in close proximity to children to have conducted a criminal history records check with the TBI and the FBI. That mandate was passed in the year 2000. Prior to that, it was permissive legislation, and school districts could choose whether or not they conducted these criminal history records checks. So that is still the case. Public Chapter 1006 requires still school districts to initiate these criminal history records checks upon initial employment, but what the law added is they have to also do that every 5 years thereafter. Now, this is a new requirement, and because the mandate, like I said earlier, was just passed in 2000, there are a lot of teachers and school district employees who probably have never had a check because they were hired prior to 2000. So what most school districts are having to do right now to implement this law is to look at every employee that would be required to have a criminal history records check and make sure that they have had one within the last 5 years. And of course, that would include anyone who was hired prior to the mandate and would have to be tested immediately. Because this is causing school districts to have to do a great deal of checks at once, there are some vendors who may be considering mobile units for fingerprinting, and directors of schools are engaging with them now. Now, along with the requirement for background checks to occur every 5 years, this law mandates that that 5-year check will have to continue until Tennessee is fully enrolled in the FBI's RATBAC program. Upon acceptance into the RATBAC program, the LEA requirement for background checks will be for every 5 years will be eliminated. And for those of you who aren't familiar with that FBI RATBAC program, it's really neat because what happens is once a person is hired by a school district and has an initial fingerprint check, they don't have to have a check thereafter because the FBI RATBAC program will allow school district administrators to have immediate notice if a teacher or other school district employee has any kind of conviction that would come up on a rap sheet. So it will decrease the amount of funds that would have to be spent every 5 years for teachers to be rechecked. I have consulted with the TBI, and there are some requirements that have to be met before Tennessee can fully enroll in that RATBAC program. And I've been told that the enrollment could take up to 1.5 to 2 years. So that is down the road, but hopefully sooner rather than later. Okay, now we're going to move on to the Teacher Code of Ethics revisions. Now, everyone knows that there has been a Teacher Code of Ethics for many, many years. A few years ago, it was codified and put into Title 49. It has also been the law for many years that the Teacher Code of Ethics, a violation of the Teacher Code of Ethics, could be a reason for which a teacher could be terminated from employment with a school district. But Public Chapter 937 actually revises the Teacher Code of Ethics, changes some of the points in the code, and it also adds the new addition that the new law now authorizes the State Board of Education to actually take licensure action against teachers for violations of the Code of Ethics. And that would even include failure to report other teachers who violate the Code of Ethics. For example, in years past, when I trained teachers on the Code of Ethics, I would always tell them that you can be terminated during your contract year, or if you are a tenured teacher, for violation of the Code of Ethics. But there wasn't an automatic licensure action that could be taken against you, or authorization in the actual law for that. And I would also get questions from teachers saying, well, if I know my colleague, maybe the teacher who teaches next door to me in the classroom, what if I know about something that I believe is a real violation of the Teacher Code of Ethics, some actions that they have taken? Do I have a legal duty to actually report that? And those were tougher questions back then. I would always start out with, well, there are certain actions that if you as a teacher are aware of them, you might have to immediately report it to the Department of Children's Services or local law enforcement because of the obligation for all teachers to report suspected child abuse. Now, that was certainly a legal obligation and still is. But for other things that maybe were less serious or a different type of behavior, I could not strongly say that there was an actual legal obligation to report. Of course, teachers have always had, moral and ethical obligations to report violations of ethics code. But now we can strongly say that teachers do have a legal obligation to report those things. And also, in addition to that change, the new law requires LEAs to provide annual training to teachers on the Code of Ethics. It doesn't say by any date, it just says annual training. So this webinar is part of what the department and PET want to provide educators so that they can easily get this annual training. Now, we are going to walk through all of the provisions of the Code of Ethics at this time. This is actually where it's codified. Title 49, so it's 49-5-1003, lists the educator's obligations to students. That is part of the Teacher Code of Ethics, and that's where it's codified in state law. There is an introductory phrase in Section A. An educator shall strive to help each student realize the student's potential as a worthy and effective member of society. An educator, therefore, works to stimulate the spirit of inquiry, the acquisition of knowledge and understanding, and the thoughtful formulation of worthy goals. It's very inspirational, that statement. Now, next it says, in fulfillment of this obligation to the student, an educator shall, and this is a long list, and I'm going to go through the list. Some of the points I will stress more than others. Some of them I think are pretty self-explanatory. Number one, abide by all applicable federal and state laws. This seems fairly obvious, but I think that, I'd like to say here, it's always good when educators try to really work to make themselves fully aware of their local board policies, which sometimes are required by law. And the education laws as they are passed, and the department puts out a legislative report every year of the bills that pass the General Assembly, and that can be found on the department's website. Teachers are encouraged to look at that, and it gets sent out to school districts annually. Also, monitoring the State Board of Education website regularly can keep them apprised of the current State Board of Education rules and any pending changes to those rules. Number two, not unreasonably restrain the student from independent action in the pursuit of learning. I think that all good teachers know that part of their job as educators is to encourage the curiosity of students and to encourage them in critical thinking, and I think that goes along with that. Number three, provide the student with professional education services in a non-discriminatory manner and in consonance with accepted best practices known to the educator. I think that when you talk about providing professional education services in a non-discriminatory manner, I think that kind of goes along with abide by all applicable federal and state laws, because we do have laws with regard to discrimination in the educational setting. So I do think some of these points are sometimes redundant, but I think they highlight some very important points. I think the one thing to remember is that when teachers are providing services to students, they need to make sure that they are giving equal treatment to all students. Number four, respect the constitutional rights of the student. Here again, there are many constitutional rights, everything from Fourth Amendment rights about not searching students inappropriately, and lots of teachers and school officials get training on how to comply with students' Fourth Amendment rights. There are, of course, First Amendment rights about students' rights to observe, religion, their rights to speak out on topics. There's much training available to teachers on those set of rights, and I think it's just being cognizant of all of those things. Not unreasonably deny the student access to varying points of views. I think that it's one thing I want to point out when you look at some of these provisions. There's a lot of language about not unreasonably or deliberately. I think that there are qualifiers in these points that are important. So when you're talking about not unreasonably denying the student access to varying points of views, I think we have to be careful not to let our personal biases get in the way of teaching. We're all human and we all have various opinions on various topics, but making sure that we're maintaining professionalism in our teaching and thinking about that. And sometimes it's important that when you're teaching a lesson that you don't necessarily let every student in the room know your personal views on every issue. Sometimes that's part of being professional. Not that you aren't human and that you don't have personal opinions, but sometimes it's best hold those back. Not deliberately suppress or distort subject matter relevant to the student's progress. I think that's kind of along the same lines of what we've talked about and pretty self-explanatory. Number 7, make reasonable effort to protect the student from conditions harmful to learning or to the health and safety. Number 8, make reasonable effort to protect the emotional well-being of the student. I think that all good teachers do this. They worry more about their students than we could ever imagine. They care about their students. And when I think about this is, I think about the state law with regard to bullying, making sure that teachers are observant of situations that go on in the classroom, that go on in the halls of the school or in the cafeteria or on the playground. And if they observe students interacting with each other in a harmful way, making sure to step up and do something about that, report it to an administrator. I think that in the past, a lot of times we thought, well, if a student doesn't file a formal complaint, maybe we don't need to take any action or do anything. But I think that the laws we have in place now, that's really not the right way to handle those situations. And just because the student doesn't happen to be assigned to your class doesn't mean that you don't have an obligation to make sure they're safe. And I think all good teachers do that. I've highlighted a few of the points, and this is one of them. Not intentionally expose the student to embarrassment or disparagement. I think this is self-explanatory, but sometimes I think about the disciplinary process when I think of this one. I think about days gone by, years and years ago, when maybe teachers would put a circle on the blackboard and have students put their nose in it, or you see the old cartoons of a student sitting on a high stool with a dunce cap on. I think that we look at discipline very differently than we did in the past, and we know that actually the word discipline comes from disciple. And what does it really mean? We're talking about teaching students. It's not always there to punish, and it's certainly not there to embarrass a student. It's to teach them appropriate behaviors. So I think we need to really think about when we're disciplining students, ways to do that aren't disparaging. Number 10. Now, we're talking about very specific federal and state laws with this one. Not on the basis of race, color, creed, disability, sex, national origin, marital status, political or religious beliefs, family, social, or cultural background, or sexual orientation unfairly, exclude the student from participation in any program, deny benefits to the teacher, or to the student, or grant any advantage to the student. I think that this goes back to making sure that we're very mindful of providing equal treatment and equal services to all students, regardless of any characteristics that they might have that are listed above. And also to remember that it's best practice to not show favoritism to specific students. And I think that's covered in some of the other points as well that we've already discussed. Number 11. Not use the educator's relationship with the student for private advantage. Now, this is a point that's generated some discussion recently since the law has passed. And I think that there are people out there who have showed concern and tried to maybe scare teachers into thinking this means that teachers can never tutor students for private gain, cannot charge a fee for private tutoring. I don't think the law is that black and white. And I don't want teachers to be so overly cautious that they don't do this anymore. I think it's a conversation you need to have, but I think what you need to think about is where there could be a conflict. And for example, it's very clear. If you have a student in class, you're teaching them math. If you tell that student, well, If you will come by my office, or if we can meet at the public library at 3:15 and your parents can pay me X dollars an hour, I will continue to tutor you on the areas where you're struggling. I think that's a pretty clear conflict. This is a current student you have in class, and it is your job to teach that student math, and that's what you're paid by the school district to do. I think that's, one of the more obvious no-nos and would be a violation of this provision. But I also think there are opportunities for teachers to tutor students outside the school day for fees when it would be okay. For example, tutoring students who are not your current students. Maybe they're students you had 5 years ago, and during the summer, you want to earn additional money and you want to help students. I think that there are times that it would be okay. I do encourage all teachers, if they have questions about an issue like this one, to talk to their principal, and then the principal can consult with their local board attorney just to make sure that it is something that is well within the bounds of ethics. So another point I've highlighted, I think this is an important point, not disclose information about the student obtained in the course of the educator's professional service unless disclosure of the information is permitted, serves a compelling professional purpose, or is required by law. Now, I know what you're thinking. You're thinking, oh, this would be a violation of FERPA, the Family Educational Rights and Privacy Act. And that federal law basically says that educators cannot disclose to outside parties personally identifiable student information without prior written consent from the parent. There are some exceptions to that, but for the most part, teachers are bound by that federal, and we have similar state laws that prohibit them sharing personally identifiable student information that comes from student records. Remember, FERPA is just about information that is gained through student records. The definition of student record is very broad. I actually think this point in the Teacher Code of Ethics is much broader than FERPA, because during the course of your work as a teacher, you have access to lots of information about students, not just information that is contained in a student's record. You observe students. You have parents tell you information. It may not be recorded in an official education record of the student, but you certainly have access to lots of information, sometimes sensitive information. So I think disclosing that information could always be inappropriate, and even beyond a violation of FERPA, it could be a violation of ethics. And so I caution you about having conversations about your students, outside of the professional setting. Even inside your school district, I always caution teachers on those faculty lounge conversations. Be very cautious with those. And sometimes teachers forget when they're having that nice hot cup of coffee, they're relaxing a minute, and they're debriefing with their colleagues. Be cautious not to violate the federal law or the Code of Ethics when discussing their day. Not knowingly make false or malicious statements about students or colleagues. Now, this is knowingly. I want to point out, there are a lot of qualifiers. And I think that it's self-explanatory. If you're spreading malicious and false gossip about students or colleagues, this could be a violation of the Teacher Code of Ethics, but it's knowingly. So I don't think you'll ever have a situation where a teacher accidentally does this and is deemed violating the code. Number 14, ensure interactions with the student take place in transparent and appropriate settings. I think this one is worth talking about, but to a certain extent, I think you have to use your common sense. It's always good to avoid being one-on-one with students if it's not necessary. But of course, there are times when a teacher can't avoid one-on-one interaction with students. And, we talked about tutoring earlier. There are times you're going to have office visits or tutoring with a student, and that's certainly appropriate. But just be mindful about doing it in the right place. I like to joke and say, don't do it under the gym behind the boiler room with the door closed. That's common sense. Do it in an open area of the school, maybe even in your well-trafficked area with a door open. And I do like classrooms or offices that have windows. A lot of teachers like to put paper up on those windows. I certainly understand why you do it, because when you're teaching, it's certainly distracting to students to see people walking down the hall. But those windows actually are your friend. They create transparency, and it helps you avoid the appearance of being alone, and you need to look at it as a protection to you. A lot of the things we're talking about today about interacting with students, they're just ways that you can protect yourself from sometimes even, false accusations. So I don't want teachers to think of these things as this is a list to make sure that teachers don't do bad things to students. This is also a list to remind teachers of the things that they can do to help protect themselves and to avoid even the appearance of impropriety. Number 15, this is a serious one. Not engage in any sexually related behavior with the student. And I think that this was one of the provisions that was heavily discussed and debated in some of the legislative committee meetings. Legislators wanted to make sure that there was a clear definition of sexually related behavior. They wanted there to be no doubt with educators of which behaviors, if they engaged in them, they could face termination or licensure action. So they really wanted to beef up this definition. Some of the things are quite obvious. Some of them, I think, we'll talk about for a second. So whether verbal, written, physical, or electronic, and I like that they added electronic. I think we need to have conversations about text messaging and social media interactions between students and teachers. A lot of school districts now have policies directly related to this type of interaction between students and teachers. So I do encourage you to check your local board policies and procedures to make yourselves aware of any specific board policies that you have. Now, as an attorney who talks to school officials every day, who works closely with the State Board of Education's attorney, who works on licensure actions against teachers, I will caution teachers to never provide their personal cell phone numbers to students and to text them one-on-one back and forth in social ways. It is best not to do that. And so I always strongly discourage it. And also nowadays, there are great apps available, and most school districts have access to those and can give teachers information about those apps, so that if you are on the beta convention field trip or a state contest or a football game and you need to be able to communicate with your students in real time, you can do that in a way that is not with personal cell phone numbers, and it protects the teacher. And if you are in a pinch and there's an emergency and you don't have access to an app and you simply must communicate with students, I always urge the teacher, we all have smartphones now. It's best to do it via email from your smartphone rather than text. It's better to always copy another school district employee, adult, when you're communicating with a student. And the reason I stress using email rather than text messaging when you absolutely have to is those emails always reside on a server somewhere. You can always recover those emails, prove what you said, what the student said, the purpose of the email. Text messaging is not that easy. And when I've talked to the state board attorney, who sometimes has to subpoena cell phone carrier records when working on a case, they are not always able, or she's not always able to get the actual text messages. Sometimes all she's able to obtain from the cell phone carrier is that, for example, 5 text messages were sent from this phone number to this phone number after midnight. Now, in my opinion, if a teacher is texting one-on-one with a student several times after midnight, I don't really care what the text messages say. That in and of itself is inappropriate. But I think that is why you can't always prove what you said if you've deleted the text message. So try not to text message students one-on-one. Now, to go further into that next sentence, sexually related behavior includes, but is not limited to, behaviors such as making sexual jokes or sexual remarks, engaging in sexual kidding, sexual teasing, or sexual innuendo. Now, that portion of the point, I think, is the one that we need to talk about a little bit. I think the last part, when you read pressuring the student for dates or sexual favors, engaging in inappropriate physical touching, groping, or grabbing, kissing, rape, threatening physical harm, and committing sexual assault are very obvious. I don't think we need to belabor those points. But when you're talking about behaviors like making sexual jokes or sexual remarks, I think we need to remind people and make sure that teachers remember their roles. Your role as a teacher is to be the teacher. You're not there to be the buddy or the friend of students. And you always have to remember those professional boundaries. And all good teachers, they want to make a difference in students' lives. And you can do that. You can do that as a teacher. You can do that as being the adult in the room. Be cautious, because students, especially teenagers, they sometimes want to press those boundaries, and they want to make jokes, and they want you to joke back and forth with them. Even if you're not initiating those jokes or telling them or really engaged in the conversation, what happens when the favorite teacher doesn't say anything against or stop that kind of behavior, but laughs the loudest in the room? That sends a message to students. And that's not appropriate either. I think that when you have a group of teenagers or one teenager that wants to press those boundaries and behave in that way, and they're testing you, they're trying to see how you react, I think it's a perfect example of a teachable moment. And good teachers take advantage of those moments to make sure and establish the relationship and let students know that it's not appropriate behavior. So sexual kidding, and I used to tell when I did HR presentations for adults, if you wouldn't tell the joke in Sunday school or to your granny, don't tell it at work. I think we have to be very careful when you're joking around with students. Be cautious to not portray yourself as a buddy. If you have certain behaviors and jokes you want to make that you are questioning whether or not it's appropriate for students, just don't tell them at all. The last part of that, like we said earlier, it's very clear. And I just have to say unequivocally that it is never appropriate for a teacher and a student to have any type of sexual relationship. It does not matter the age of the student or the teacher or their genders. It seems silly to even have to say that, but I have been asked specifically the question by a teacher years ago, if I have an 18-year-old student and it's consensual, is that sexual harassment? Is that a problem? And I did have to explain to the teacher that even if it's not possibly a crime because the student is 18, it is definitely a violation of the Code of Ethics, and you will be terminated from your employment, and it is a reason for which the state board could revoke, and if proven, would revoke your license. So the important points bear repeating. Number 16, this seems a little bit obvious: not furnish alcohol or illegal or unauthorized drugs to a student. 17, strive to prevent the use of alcohol or illegal or unauthorized drugs by the student when the student is under the educator's supervision on school or LEA premises during school activities or in any private setting. I mean, I think that's you need to note that that's in even private settings. Of course, 16 and 17. 16 is more than just being unprofessional. It's against the law. So I think that is pretty obvious. I think with number 17, it's especially important if you are a teacher who has been named to be maybe a sponsor of an extracurricular activity. I always tell school administrators, the people you select to be sponsors of those extracurricular activities need to be your teachers who have the highest level of judgment, that you have complete trust in their ability to make decisions with regard to students, even in off-campus settings, because those are the teachers who have more opportunities for more intimate interaction with students. And they are truly, you know, the old Latin phrase, in loco parentis. Those teachers are truly standing in the place of parents. So when you're in a hotel at night, you do have a legal obligation to strive to make sure that those students aren't slipping out of their rooms, aren't bringing contraband into their rooms, and that you report those things immediately and take action if you do discover that that is happening. Number 18, refrain from the use of alcohol while on school or LEA premises or during a school activity at which students are present. I think that's pretty obvious as well. I would caution you to not to avoid even the appearance of impropriety. And I have it's a little bit funny, a story about a group of school officials who took some students to an out of town contest, and they were chaperoning. And on the way back, they stopped at one of the big chain restaurants, one of the ones that have, you know, the little fruity drinks that have the fruit in them and the fancy glass and umbrellas and things. And the teachers ordered them. Now, granted, they ordered the non-alcoholic version of those drinks, as they should have, but they wanted a pretty glass and a pretty drink. Well, students, you all know, they take pictures. They took pictures of the group and of the teachers sitting at the table eating. And by the time those pictures had gone around town, people who weren't there were just convinced that the teachers were drinking alcoholic beverages while they were chaperoning the children. And you can imagine the uproar that caused in that community. I mean, word of that traveled before the bus even rolled back into the school parking lot. So, not to say that the teachers did anything wrong, but you always need to think about the appearance and things that you can do to protect yourselves from having to explain that, by the way, they were not alcoholic beverages. They were pretty fruity drinks. I just thought that was a funny story. Teachers probably have stories like that they could share. Number 19, maintain a professional approach with the student at all times. I think that this is probably one of the more important points overall. I think that this undergirds everything, everything from showing affection to students, how you interact during school social events, how you interact with students off campus, and even social media interactions. When you're talking about showing affection, I think just being mindful that students, children, just like adults, some have different approaches to interacting, and some students don't want to be hugged. Some adults don't want to be hugged. And, as a lawyer, I always tell people, if you want to avoid all legal risk, it's best not to touch students unless it's absolutely necessary. I don't want to be harsh, and when I say this to the pre-K and the elementary school teachers, I get booed sometimes, and we're going to hug those babies. They say, that might be the only love that child gets all day, and I certainly understand that. I just say that to say, to bring out the point, to think about those interactions and use good judgment. And also, you don't know always the background of students and different things that can affect how they interact. Also, if a student ever makes you as a teacher feel uncomfortable, number one, that's a teachable moment. You need to correct that behavior. And you also need to report it to an administrator, because in the same way that we try to protect students, teachers need to be protected as well. School social events. You would be surprised how many calls I get about school social events. I've received calls from parents complaining about, here's my favorite example, how a teacher danced inappropriately with a student at a 7th grade dance. This was years ago, I had up to like 13 or 14 calls. I learned everything from the song they danced to, where the teacher and the student's hands were placed, where they sat next to each other in the bleachers during the school dance. I immediately turned that over to the director of schools for an investigation. I don't know what happened exactly, but I do know if the teacher had not been dancing with a student in that way, we probably wouldn't have received so many calls. So I think if you're there to chaperone a dance or a school event, remember you're there to monitor student behavior. You're not necessarily there to engage in the activity. So just be cautious about how things can be perceived. Off-campus interaction is something I like to touch on as well. The same communities that you as teachers you live in and teach in, you have children. Your children may be friends with current students, former students of yours, and there are issues that happen in private settings in your home that you need to be mindful of. Because your principal, it can create a situation where your principal gets called on Monday morning about something that took place in your home. Just always, like it or not, teachers are held to a very high standard, and you do have the right to a private life. But I do caution you as a teacher to be careful about even your off-campus interactions with students. I want to take a minute to just talk about social media interaction. There are a lot of things, I talk about, touching students and being cautious about that and using your own judgment. But when it comes to social media, I have a hard and fast rule that I think a lot of school districts have adopted for their own local board policy, but I don't think it's ever appropriate to friend students on Facebook or, Instagram or Snapchat or whatever the new social media platform students are using is today. I just don't think that it is appropriate. It's professional. It protects the teacher. So I think that that's a good rule of thumb. And even though you're not going to friend students, I think as a teacher or an employee of a school district, you need to always set all settings on social media to private. So you're not going to friend students. You're going to set everything to private. What else are you going to do? I think you're never going to, and this is my rule of thumb, never put anything on social media that you wouldn't want to see on a billboard on I-40. I mean, that's just a good rule of thumb, because private doesn't mean that, and just because you have 300 friends on Facebook and they're just your friends, doesn't mean that they won't share your post with others and even your administrators. So be very cautious. Twitter is not a place to vent about your workday. If you post something about your workday, it needs to not mention students, because here again, you could violate the Teacher Code of Ethics by a tweet. You could violate FERPA and other state laws about the confidentiality of student records. Doesn't matter if you mention the student's name or not. Remember, it's about personally identifiable information. So if you mention something that people could actually figure out the student you're talking to or talking about, that's just as much of a problem than if you actually mention the student's name. And also, let's put aside the concerns about violating the FERPA. If you are constantly venting about your day on social media, it really, I think it takes away from professionalism. It could make your administrators question your judgment. So I think that even if you're not violating the law, I would be really cautious. My rule of thumb, if I put anything on social media about my job, it's always something very positive, like doing a webinar today with Pat about teacher ethics. So excited. It's never anything where I'm upset. If I'm upset about something that happened during my day, I'm going to just go home and have a private moment and maybe scream into my pillow. I think that's the best advice. Okay. 49-5-1004 is also part of the Teacher Code of Ethics, and it lists the educator's obligations to the education profession. There's an introductory statement. The education profession is vested by the public with a trust and responsibility requiring the highest ideals of professional service, in the belief that the quality of the services of the education profession directly influences the nation and its citizens. The educator shall exert every effort to raise professional standards, to promote a climate that encourages the exercise of professional judgment, to achieve conditions which attract persons worthy of the trust to careers in education, and to assist in preventing the practice of the profession by unqualified persons. Now, there's the introductory phrase, and then there are individual provisions. In fulfillment of this obligation to the profession, an educator shall not deliberately make a false statement or fail to disclose a material fact related to competency and qualifications in an application for a professional position. Now, it has been longstanding law in Tennessee that falsifying a job application is cause for termination. So if you lie on your job application and you get hired, your school district can immediately terminate you once they find out that you have falsified your application. That's also a reason for which the state board can take action against your license. Falsifying your transcript and those kinds of documents to get a license is also a reason for which the state board can take action against your license or fail to give you a license, or you can be terminated. It doesn't happen often, but I've been with the department for, 18 years now, and I have seen situations where we have discovered that a person has actually falsified their school transcripts, and we had to take action. And I have heard from districts from time to time about educators falsifying things on their job applications, specifically not being truthful about their past criminal history, things like that. So be very cautious about that. You shall not misrepresent the educator's professional qualifications. I think we've talked about that. Or here's a slightly different point. Assist entry into the profession of a person known to be unqualified in respect to character, education, or other relevant attribute, or knowingly make a false statement concerning the qualifications of a candidate for a professional position. When I hear these 2 points, it really makes me think about maybe giving untrue references. If someone asks you for a reference check about an applicant for employment that they are considering hiring, and you knowingly make false statements about that person's past work or past history, that is very serious and, basically could put children at risk possibly, is a violation of the Code of Ethics and a reason for which you could have action taken against your license. Assist a non-educator in the unauthorized practice of teaching. Lawyers have a code of ethics, and we have a similar provision in our code of ethics, assisting a non-lawyer in the unauthorized practice of law. So this is a common provision in codes for professionals. Disclose information about colleagues obtained in the course of professional service unless the disclosure serves a compelling professional purpose or is required by law. I think that there are a lot of things that we might learn about our colleagues in the course of work that are necessary. They may be sensitive, they may be private, they may be related to a colleague's illness, maybe a struggle they're having at home. Maybe you're a principal and you have to know things about your employees. Those aren't appropriate conversations to have at your neighborhood barbecue to say, guess what I found out about Miss So-and-so at work. And the same way, if you're a teacher and you find out information during the course of your workday that's sensitive, it is never appropriate to disclose that information that you have obtained for a professional purpose. Knowingly make false or malicious statements about a colleague. I think anytime there is, malicious or false gossip going around, that damages the profession, and it creates situations where communities see teachers in a not so good light, and that could damage the profession. Here's one I wanted to highlight. Accept any gratuity, gift, or favor that might impair or appear to influence professional decisions or actions. The first thing that comes to mind is gifts that teachers receive. Maybe at the holidays, you receive small gifts or tokens from your students or parents. I don't think this law at all, and I've heard people say from now on we have to tell all students and parents we could never accept a gift at the holidays or any other time at the end of the school year. I don't think that that's what that means, and I don't want people to overreact, because when you read this statement, it says any gift or gratuity or favor that might impair or appear to influence professional decisions or actions. Now, if you get a small token of appreciation from a student at the holidays, I think you need to look at, could it in any way impair or appear to influence your professional decisions? And it's the same way. We have ethics. Governor Haslam has an executive order on ethics for executive branch employees, and that applies to employees of the State Department of Education. And we can't accept gifts from vendors or from entities where we in any way monitor or regulate. And so if I go to a school district and I do a training, I, of course, can't accept a gift that might, impair or appear to influence my professional decisions. But there are always exceptions for small tokens of appreciation. So I tell teachers, obviously, if it's something that's readily convertible to cash, or it's, of such value that it could be, and it's not that it necessarily would influence your professional decision making. It's if it could have the appearance. So avoid even the appearance of impropriety. So I like to joke that when the little girl gives you that small Avon bottle of Sweet Honesty perfume at the holidays, that's probably not the biggest problem. If her parents are buying you a 5-day cruise, that's something to be more concerned about. So I do think that this isn't a black and white rule, and you need to work with principals. If you receive a gift that makes you uncomfortable or that you fear could be above and beyond what you can accept, always talk to your principal. Your principal can talk to board attorneys, because these are very fact-specific issues, and that's why when I give examples, I try to give kind of very obvious examples, because there's some gray area, and but I think we always need to err on the side of caution, but we don't want to ever hurt a child's feelings or a parent's. I think sometimes it's how you present these things to them that matter the most. Use illegal or unauthorized drugs. Well, that's a violation of the law. So we know based on other provisions that that's a violation of the Code of Ethics and a breach of professionalism. Absolutely. Fulfillment of this obligation to the profession, educators shall administer state-mandated assessments fairly and ethically, conduct themselves in a manner that preserves the dignity and integrity of the education profession. These are pretty overarching things. When we talk about administering state-mandated assessments fairly and ethically, all teachers receive training on how they behave when they're proctoring exams or interacting during the statewide assessments. And there are some very clear rules about what is included as a breach of test security. And for as long as I've been with the department, a breach of test security can be a reason for which a teacher can lose their job or can lose their license or have licensure action taken. So just be mindful of those rules, attend those trainings. And if you have any question about an action or something that behavior during an assessment, feel free to ask ahead of time. And with the department, we're always happy to address questions, because we know that you have them sometimes about interacting with students during the testing window. And then, of course, number 2 at the bottom here, conduct themselves in a manner that preserves the dignity and integrity of the education profession. I think that's, an overarching point throughout this whole teacher code of ethics, is to ensure that you are maintaining professionalism, good judgment, that you are maintaining boundaries with students. You're there to be their teacher and not their friend. I'm often concerned when we have teachers who are there and they really want to be the popular teacher. They want to be the teacher's buddy, the student's buddy. And that's not always the best role to take. And reminding yourself of that from time to time. You may not be the most popular, but the teachers that I remember the most fondly are the ones that really set those professional boundaries, that were good role models. I look back on the ones that were probably too much in the friend zone with students. And, as an adult now, I look back and think, ooh, that teacher needed this training. So I think those are the things we need to remember. Now, this next slide, it says licensure standards, but I wanted to show you this law requires that the State Board of Education post the Teacher Code of Ethics on its website, and this is the actual link to the State Board's page where they post the Teacher Code of Ethics. So if you have any questions and you want to go back over these or review them from time to time, go to that site. Now, moving on to another law that passed during this past legislative session, Public Chapter 935 actually requires a director of schools, directors of public charter schools, or directors of non-public schools who learn of a teacher who has been convicted of certain offenses. They have to actually now report those convictions to the State Board of Education. Now, when I say for certain offenses, I didn't want to list the statutes. They're listed in that public chapter, but I will say there in state law, there are a number of convictions that are so serious that the law says that the state board shall automatically revoke a teacher's license if they've been convicted of those listed offenses. And those listed offenses, like I said, are very serious. The first one is statutory rape by an authority figure. Another is a list of statutes that the convictions are for the manufacture, delivery, selling, or possession with the intent to manufacture, deliver, or sell controlled substances. So those very serious drug offenses, the state board can also automatically revoke your license. Then there's one last statute that is a long list of serious crimes that include murder, kidnapping, especially aggravated robbery, aggravated rape, sexual exploitation of a minor, rape, those really serious offenses. Now, the difference between the automatic revocation and the language that says the state board could take licensure action is that those offenses that are the most serious and that are listed in the law for auto revocation are those things that the state board can automatically revoke a teacher's license without providing them the right to a full hearing before the board before taking that action. And I think the General Assembly just agreed that these are such serious offenses. If there's actually a conviction, there needs to be an automatic revocation. Now, this law also requires directors to report teachers who have been suspended, dismissed, or who have resigned following allegations of conduct including sexual misconduct, which, if substantiated, would warrant consideration for license suspension or revocation under State Board of Education rule to the State Board of Education. This is longstanding practice. This has been a requirement that has been in the State Board of Education rules for many, many years. It is now codified in statute. The General Assembly thought it was important enough to actually put it in state law, but basically, this is not new. This law has always been the practice of the state board for as long as I could remember and was actually in state board rule. Now, remember we talked about the definition of sexual misconduct in the previous public chapter about teacher ethics. This public chapter also defines sexual misconduct very thoroughly, and you will note it's a very similar definition to the one we previously talked about. And it does make clear that sexual jokes, sexual remarks, sexually suggestive comments, and sexual kidding and teasing are actually part of that definition of sexual misconduct. So I think it's cohesive. The same definition that's in the Teacher Code of Ethics is also in this reporting statute. Also, in the past, the state board rule said any director of schools who fails to report teacher misconduct as required to Department of Education and also the state board could lose their license. There was some discussion during the legislative hearing on this bill that not all directors of schools actually hold a teaching license, and that the state board would not have a lot of action or authority over someone who does not actually hold a license. Because if you'll note, in Tennessee law, to be a director of schools, the law only requires the person to have a bachelor's degree. Now, we know that even though that is the minimum requirement, I don't know of any school district in Tennessee that does not have a policy requiring way beyond that, but just wanted to mention that because it is an interesting fact. So now this law authorizes the State Board of Education to reprimand a director for failure to report, a public reprimand. So that's in addition to being able to revoke any license that director holds. There was a separate law passed to make teacher disciplinary actions public. PC 936 requires the State Board of Education to transmit final disciplinary actions on educator licenses to the National Association of State Directors of Teacher Education and Certification. This is a national clearinghouse that collects data across the country. So if a teacher loses a license in Tennessee for a bad act, that goes into that database. So if that teacher moves to, say, Utah and tries to get a Utah license, Utah can look up on this database and see that, wait a minute, this teacher once held a Tennessee license and they lost that license for misconduct. So because a lot of states have, including Tennessee, if you have lost a license in another state for misconduct, they will not grant you a license in their state. So this is just about transparency. And here again, this is really not new. This is a practice that the department and the state board have conducted forever, as far as I can remember. But the General Assembly wanted to be clear that this was an important requirement and that it was consistently practiced with all disciplinary actions. And so they've added it to actual state law. And this law also requires the State Board of Education to post on its website all of its final disciplinary actions on educator licenses. You could always get this information. It has always been a public record, and you could request it of the state board, but a lot of people and media outlets complained and thought it was problematic that this information should be more readily accessible to the public, so they now are posting it. And finally, Public Chapter 938 was passed that prohibits employment assistance for perpetrators of sexual misconduct. Basically, it prohibits local education agencies from entering into a non-disclosure agreement during or as a prerequisite to settlement for any act of sexual misconduct. And I'll tell you what this has looked like in the past. When I first started working in the world of education law, I occasionally would see a situation where a teacher would be investigated for misconduct, and they would get a lawyer, and the lawyer would say, school district, if you would sign this non-disclosure agreement, we won't appeal this decision, we will resign and go away quietly. And sometimes the non-disclosure agreements even stated that the school district would not report the action to the State Board of Education, which in my opinion has always been a violation of the state board rule and has never been appropriate. Occasionally it would happen. So now there is a state law prohibiting this action. It prohibits employees even further from assisting others in obtaining employment if the employee knows that the person has engaged in sexual misconduct involving a minor student. So any of those false, we talked earlier about false or negligent references. If you lie to someone who's about to hire an applicant and tell them that they have a clean record, and when they worked in your district that there was never any allegations of wrongdoing, that would be a violation of this law. So I think that those are things that have always been problematic, but the General Assembly wanted to just make it very clear to everyone. And also the federal ESSA every Student Succeeds Act required states to have a provision like this in their state law. So while it codifies what has been the long practice in Tennessee in state board rule, it also complies with a new federal provision to protect children. So this is a very quick walkthrough of some recent important legislation. So I hope you enjoyed it and it provided something for you to think about. I think having these conversations often is important for the profession, and it raises questions that sometimes that need to be addressed and can be addressed by your administrators or by your local board attorney, or feel free to call the State Department of Education, and we're always happy to assist.
Wow, that was very, very much needed to hear. I think it's going to be helpful to a lot of educators. Christy, I really thank you for sharing that with us. And I think it's going to be useful for educators to spend some time reviewing this. We did have a few questions, though, that have come in. And we wanted to ask those of you. And I think Mike is also on the call. So we're going to take that and ask you this. As you know, educators must behave in an ethical and professional manner. And they realize that their actions reflect directly on the status and substance of our profession. So one of the questions that came up, and we hear this a lot, a principal chastises the teacher in front of other educators. Doesn't the ethics encourage private conversation, and how should a dressed-down teacher react?
I think this is a good question, JC, and it makes me think of the provision that we just talked about that talks about the obligation to the profession for teachers to conduct themselves in a manner that preserves the dignity and integrity of the profession. And I think that it's never professional in a school setting or in a corporate setting to address colleagues in that way. And it's always best to have, more private conversations. And it really puts the teacher in an uncomfortable position. And I think if I was the teacher, I would always, or encouraging a teacher to just take a deep breath and try to politely ask if we could continue the conversation in a more private setting. Try not to, inflame the situation anymore, and you're always having to remember as administrators and teachers that when those things happen, you have colleagues watching, you also have students watching in a lot of cases. So it's definitely about preserving the dignity of the profession and setting a good role model for students.
Mike, anything to add?
Yeah, sometimes it's not the principal and the teacher, it's between teachers sometimes where they have a disagreement regarding a project or working together. So this is not really a question as much as a comment. I would assume that level of professionalism would also apply to those situations, because there are some disagreements that do occur, but I think a commitment, like you say, Christy, to who's watching, what's going on, and how do you maintain your level of calmness and, professional relationship with colleagues is important too.
Very good. We have a call from Jan from Memphis. Jan asked about the professional relationship between students, I think both inside and outside of the classroom. One of the issues she raised is she receives social texts from her students regarding homework every night. In addition, she's also on social media with them. How should the teacher respond? And I believe I know this answer.
Well, I think we talked at length about this, and my advice is that there should never be a student texting you on your personal cell phone at home, because to do that, you would have had to have given it out. So I would really caution teachers to not give out their personal cell phone numbers, because you can avoid this very situation by doing that, and talking to the tech people in your school district or your administrators about apps that you can use to communicate things like homework assignments and to provide help to students. So I think that's the first thing. And also, just to reinforce that a lot of school districts now have social media policies, and they strongly discourage and sometimes prohibit teachers actually friending. I guess friend is the term with Facebook, which we are all mostly familiar with, friending students and communicating with them that way. So I still strongly discourage that.
Mike, anything to add?
No, I have another question though that's been submitted from John. It basically involves a situation with a teacher who continues to complain about a relationship with their direct report, and this teacher tends to share that disagreement throughout the school environment with colleagues. How would you suggest that the teacher and the school environment would handle that, Christy?
I think that's an example of a question and call I've gotten frequently from school administrators. And, while teachers do have First Amendment rights to speak out on matters of public concern, if they're venting about something very, personal with their relationship with their administrator, it doesn't sound like that would necessarily be a matter of public concern. And so putting that aside, I think that it goes back to what I was saying about venting publicly, whether it's in the halls of the school or in the teacher's lounge or on social media. It's not professional, and people, even teachers who might think, well, this teacher may be right, maybe there is something going on there, they will not see you as professional and will not see you as having good judgment. And it could impact your future employment. I just think that's just goes back to maintaining the dignity and integrity of the profession. And I tell school officials that, determining the judgment of your teachers is so key. And once you really lose faith and trust in a teacher as having good professional judgment, it's really hard to repair that.
All right. Christy, would you mind commenting a little bit on testing protocol and the actions and inactions and the boundaries and requirements of a proctor in an exam? I know you can't go through the entire scheme of what goes on, but as you know, we learn of some incidences now and then where we feel like it's not within the lines of requirements for an objective testing environment. Would you mind commenting on that a little bit?
Sure. I mean, I do sometimes work with the state board and hear about some of the reports of breach of test security. Some of the things that we hear actually require the department to nullify test scores because they really impact the testing experience that much. Some are, maybe don't require that extreme of an action, but they are a breach of the test security rules. The common ones we see, if you're going to proctor a test, you have to be in the room. I've occasionally heard of teachers who left students unattended during the test. I mean, it doesn't really matter what the reason is. You can't leave students unattended during the test. That is a violation of the rules when proctoring. You can't make copies of the test. That's a big no-no. We occasionally hear people who do that, or even post them on social media. I mean, that is a breach of test security, absolutely. And it can have a huge impact because once a test item is disclosed outside of the testing experience, it requires the department to take that and remove that from future tests. And developing test items is a very costly and serious and a lengthy process, as most people know, and it can cost money and time, as well as it could impact your employment. Also, we occasionally hear about teachers using cell phones in the classroom while tests are being taken. That is an absolute violation of the rules and can be deemed a breach of test security. And sometimes we hear of issues that teachers don't intentionally do these things. They just make mistakes. They forget for a moment. But I think that before every testing window, it's really good for administrators to make sure that all teachers are familiar with these rules, and just everybody needs a reminder so they don't have an oopsie during test time.
Thank you. Yeah, and I think one of the things, Christy, I would mention, there's sometimes we've had teachers who have had to fill in for testing, because this is one of the bigger ones we hear from, and they weren't trained to administer tests, and so therefore they in filling in, and they have made mistakes, which has actually jeopardized their license.
That is very concerning, and the department has noted, and the assessment team has talked about ways that we can better provide trainings to teachers and send training modules to school officials so that doesn't happen. No teacher should ever go into the testing window feeling that they are not prepared to understand all the requirements of them, and so that does not need to happen. And any teacher who feels like that they haven't received appropriate training should reach out to the department, because we want to make sure that everyone understands.
So, Mike, I think you had a good one, I think, that you were dealing with yet a couple days ago on IEPs and confidential information. You want to share that and see if Christy has an answer?
Yeah, there was an incident where an educator was discussing a special needs IEP plan with an aide, and just so happened there were a few students in the immediate area, and the child got made fun of, and there was some, unhappy parents, and actually the educator had no idea it was going on. It just happened without thinking. It was not an intentional abuse or embarrassment of anyone, but it nonetheless happened. So you have thoughts on how maybe teachers could handle that a little better?
Oh, that's an example I've heard before. And, it raises the issues that we talked about during the session of FERPA and other state laws that, protect the privacy of student information. It's really, FERPA and student records, it's not the most exciting topic, but it's so vitally important, and it can really create huge problems like the one you've discussed. So I think that every school should issue reminders to teachers to be very cautious about conversations that they have about students' personal records and information, and to always have a rule of thumb to do it and to step into another room, because anybody can overhear those conversations, and it can create real problems and a heartache for students. I have a similar example that happened several years ago. I got a call that a teacher who happened to be a parent of a special needs student walked into the faculty lounge of a school where they worked, and that's where the copy machine was. And she found her child's complete file, special ed file, IEPs, full psychologicals, and everything laid out on the copier. Apparently, the teacher or administrator who was copying the file had to step away to take a phone call and left it all out. So not only did she find, information that she had no right to have access to or didn't as a student, it was actually her child, and she was very upset. And the school had to do additional training. So I think it's not just those conversations. It's about maintaining the records in a way that they're not just accessible to everyone. Teachers have to remember that just because it's an education record, if you're not the teacher providing a service or teaching that student, you don't have the right to have access to every child's record in your school. And I like to talk about the clean desk policy. Everything from engaging the password protection on your computer when you step away, to locking files in a drawer to protect the confidentiality of them. And that goes along with having professional conversations in a private place.
And one of the things that we're beginning to see, and I think ultimately this may end up needing further legislation. And so I'm not going to put you on the spot with this one, but we do see and we hear a lot about disruptive children affecting the ability of the teacher to conduct a lesson plan. And and so you're getting the disruptive child who is disrupting education for the other students in the classroom. And so the question becomes, well, do those children have rights, or do some children have rights that exceed the rights of other children? Not so much to put you on the spot, just kind of a few thoughts that you may have on that.
That's a question I've gotten a lot over the years. And in fact, my first 2 years with the department, I served as the attorney for the special education division. And I got this question quite a lot when I would travel and speak to teacher groups. And because I feel like sometimes we're talking about a child with special needs who may have a behavioral disability, and maybe they misbehave a little more than the average student, and there are other students that maybe suffer from the disruption and teachers are frustrated by that. That's a really tough situation. I will say that the IDEA does have special protections, the federal law on special education for students who have disabilities and who have IEPs, and they need to be educated in what's called the LRE, or their least restrictive environment. And that's generally going to always start with, the first place is the regular ed setting, and to hope that they can be in the regular ed setting with supports and things. Now, I will say that if you have a student that is a constant disruption in that setting, there may be questions that need to be asked. You need to talk to the special ed director and the principal, because if the student is disruptive every day, they may not be successful. It may be more than they can handle. And I always think that the first step in that situation is to maybe talk about an IEP meeting to determine if that is the student's least restrictive environment. And are there some other supports that can be put in place to help the student be more successful? Also, one thing I always caution teachers, though, in that situation, if parents or other students and parents are complaining about a student, you got to remember FERPA. You always have to be cautious not to say, well, Johnny has an IEP, Johnny has a disability, that's why he's disruptive. We have to, what I tell teachers is you have to say, I can't talk to you about another student in the same way that I wouldn't talk to another parent about your child. So that would be the one caution. No matter what's going on, do not talk about the individual student's issues, but do talk to an administrator, and maybe it's time for an IEP meeting, because if the student is continuously being disruptive, that student's probably not being successful either. And it's about helping that student and helping the other students in the class.
And I think we got time for one or two more questions. We want to jump down to questions we hear, Mike, I think about the employment contract. I think teachers have called in. I know we've had calls in this week alone on teachers who want to resign their position and their days of notice. Any thoughts, Mike and Christy? You want to talk about that aspect of it, and what are their obligations to the educator when they're willing to resign?
Yeah, Kirsty, let me add something to what, if I could, what JC just mentioned, because we have had some real situations like that, ranging from, do I have to give them 30 days notice, to do my sick days apply to this period? And when we hear those questions, we look at the ethical obligation as well. Not just the legal one. What are your thoughts on those attitudes toward separation from the school district and the obligations of the teacher?
I've actually had this question recently. I mean, we get it from time to time, where a teacher wants to go ahead and resign, and take another job and leave without giving the 30 days notice. There's actually, a statute in Tennessee requiring a teacher to give 30 days notice. Now, there are some exceptions to that for medical situations.
Right.
And some other things. And also, if the director of schools agrees to release the teacher in less than 30 days. And to be honest, in most cases, I've seen directors will agree to release a teacher unless they're just really in a bind. And because nobody wants to hold a teacher in a position, against their will necessarily. But it's important for teachers to know that there is a statute on this. It's not just best practice, and it can impact their tenure and their license in the future if the director of schools decides to report that they left them with less than 30 days notice. Also, going to the sick leave issue, what I think you're talking about is someone wanting to apply sick leave and just say, this is my notice and I've got all these sick leave days, so I'm just going to leave early. That's not appropriate because sick leave has to be used for sick leave, and school districts can actually require documentation from a physician on that. So I think I would be very cautious of teachers just saying I'm going to call in sick and not show up for the rest of the time because I think that it can impact their final check possibly, and it's certainly not the ethical thing to do.
Absolutely.
Well, it's really been an honor to have you, Christy, and we really appreciate you taking the time to answer questions, to do a webinar that I think is going to benefit educators across the state, not just for the short term, but for the long term. We have a really honorable profession. We've done a lot to keep it honorable and to continue to build on it. We see a lot of morale issues, points in time across the state, which we think we can work on together and address. But we also know that we have to do our part of it and abide by the rules and the regulations that the state set forward. And we want to continue to work with our teachers. I mean, obviously, we pushed the Teacher Bill of Rights. That was one of our things to frame the issue in a proactive manner. But this is the guidelines that the state has given to us for our profession and how we should behave. We appreciate Christy being on the call, Mike being on the call. And at this point, we want to thank you again. And Christy, any parting shots?
I just so appreciate being asked to participate. I don't often get out in the field and train teachers as often as I would like, and it's one of my favorite things. I grew up with 2 aunts and a mother who taught school for their career, and so it's always a pleasure to assist teachers.